Hi, welcome back to Legal Hour with Connaughts. My name is Anam Rana. I'm a solicitor advocate, and to my left is Awais Javed, a solicitor. This is a platform where we deal with your legal queries and changes with laws and anything, basically, even live queries that we receive on our Facebook page. So I would start by asking questions in terms of the recent changes in law to Awais, and he will then answer them one by one. So there have been changes in Tier 1 entrepreneur visa and the investor visa. So what are those changes?
Hi everyone. Basically, I think it was a hasty attempt by the Home Office to try and publish a statement that there may be some changes coming to investor visas, and route will be immediately closed for further applications. The applications already in the system will continue, but Home Office has now clarified that this wasn't the case, and they're still taking further applications for Tier 1 investor visas. I think 2 newspapers published this report as well, and that hence the panic. There were also rumors that Tier 1 entrepreneur visa will be closing down as well for £200,000 category. But now the ministerial statement has been published, and what it shows is that there will be changes coming to this category, but not now. It will be sometime in March or April. It looks like it will be probably post-Brexit, where they want to make it more robust in a sense that there will be endorsements required from what the statement says sponsors. It's not clear what does that actually mean. So whether the endorsements will be required for the business plan for these Tier 1 entrepreneur applicants from any professional bodies or people who are sponsoring them in terms of finances, or it could be relevant business bodies where the type of business they want to start, etc. So this is what we know so far. As soon as further information comes out, we will obviously share with our audience, with our clients. We'll put it on our website as well, like we always do. So stay tuned.
And can you please tell us a bit more about the short-term agriculture category?
Oh yes, this is one of the changes that were announced because of the Brexit issue. So bear with me 1 minute. Yeah, so these were the changes that were announced previously. At the moment, we don't have too much information. All we know is that there will be a Tier 5 category for agriculture sector, where short-term visas will be issued for those who can come and work in the agricultural industry. This is to support the industry post-Brexit, where a lot of people will be leaving, and a lot of European workforce who works in the agricultural industry will be leaving the country. So just to support that sector, this is being announced. Further details will come out soon, but at the moment all we know is that there is a pilot scheme which will be brought into effect soon, sometime in spring this year.
Okay.
So hopefully all the shortfall in this industry will be fulfilled. It's not clear at the moment whether it will be specific to any area, or will it be something a category which is open to everyone throughout the world to make these applications? What would be the procedure for making these applications, qualifications required, etc. Whether there will be any experience required in the industry or not. Unfortunately, not much information is given, but clear indication is given by the Secretary of State that this scheme will come into force very soon.
Okay, thank you. And there's also been changes in relation to Appendix FM regarding domestic violence in relation to the dependence of refugee applicants. What are the changes for that?
Yes, I mean, as you can see, we're moving from one topic to the other. It's intentional because there are a lot of changes that have come in, and they are not all in one category. So we just want to discuss some changes that have come into force, and we will discuss as many as we can today. So this change, generally speaking, if you are a spouse of a person who's settled in the UK, and either you came in on a spouse visa under Appendix FM, or you switched in country from a different category to a spouse visa of a person who is settled in the UK, either a permanent resident or base citizen or a European national exercising treaty rights. If one of the spouses faces, or migrant spouse faces domestic violence, then there was a category excuse me, there was a category open to them to make, still is, to make an application to apply for indefinite leave to remain in domestic violence issues. They have to prove that there was a domestic violence that was taking place, and the whole list of evidence that was to be provided is available under the immigration rules and Home Office guidance. It wasn't extended so far to other categories who are considered to be temporary migrants. So anyone who is on point-based system, if their spouses, their dependents face domestic violence, they do not have access to this category because their spouses are not considered to be settled persons. Similarly, anyone who was on a refugee visa, so initially refugee status, unless you are a minor, generally it is at least for 5 years, and during that time, if your spouse comes to the UK, or someone switches in country to a spouse visa under appendix F and meeting the income threshold or otherwise, and they face domestic violence, this category for indefinite leave to remain was not open to these spouses of someone who is on the refugee status, unfortunately. But now this is not the case. It's been a mandate. Home Office has published new guidance where this category is even open for those who are dependents of refugee status. So if your spouse has a refugee status and you feel domestic and you suffer with domestic violence, you can make an application under using a form DV under this domestic violence category. Excuse me. So in this case, this category is now open, which is a very good sign. A lot of cases we have seen previously where we made applications for dependents who were dependents of refugees or temporary migrants. Temporary migrants still the case. They had no recourse if they come to the UK as a dependent and feel suffer domestic violence. All they have to do is probably either find another category or leave the country, which was very unfair for them because a lot of them have off-rooted them from their home country, left their jobs, maybe made a lot of sacrifices to come to the UK as a dependent, and then they face domestic violence. They have nowhere else to go. But it's a good sign. It's not extended to other temporary migrants as yet. We hope that it will, but at the moment it's only extended to those who are dependents of refugees.
Okay, thank you. I mean, speaking of changes, there have been a lot of changes when it comes to application forms as well. A lot of paper-based application forms are now online. So there's been a transition from paper-based to online versions, which now means the date you submit it online is considered to be the date the application is submitted. So if you submit an application, say on the day it's expiring, your visa's expiring, leave's expiring, then it's considered as being submitted regardless of whether documents are sent to Home Office.
You're talking about this new online
system that has come
so
over.
Is it for every application?
It's not for every application. It's actually for not all applications, certain application, but EEA at the moment.
Okay.
At the moment, that's the transition. Might change. It might progress to EEA as well, but at the moment it hasn't progressed to EEA. And the way the system works, when we submit the application online, we are issued a biometric enrollment letter straight away. Okay. So
no more
instantly,
waiting for the biometric
we
letter
no longer have to wait months for biometric letters to come in, and then we have 15 working days to enroll our fingerprints from the date of the submission of the application online. And similarly for documents, we receive a checklist at the end of submitting the application online, and like the biometrics, we have 15 working days to submit the original documents to Home Office at the given address.
So it's more like what you used to do for entry clearance applications, where you submit application and date of submission will be considered the date of application.
Exactly.
And then you have time to submit documents. So it gives you as a practitioner more time to
do with the deadlines.
To work on deadline and work on the arrange documents and submit it. So even if someone is rushing to submit an application, they have a deadline, they can submit this online form and it will be considered submitted. And for documents, they have more time.
Yeah, that's correct. Although those are the benefits to this, there are slight caveats to this. So there are issues where, for instance, if someone does not have leave it asks a lot of questions on the online application form, which are mandatory questions. You cannot skip those questions. You need to mention the status in terms of passports, whether they're expired or not. They ask for whether you have a valid passport, and you have to give an expiry date. And there's certain issues we are facing at the moment in terms of submitting applications for certain people who have expired passports, but I will not go into the detail of that just yet.
Yes, I mean, it'll be interesting for our clients to know, because previously we could amend these details
On
by
the
hand
form.
on the application form, and we could explain in our obviously representations cover letter.
Definitely.
So you're saying that on this online form there is no option of
There's no
manually
option.
typing,
No.
and if you can't type the information they require, you can't move forward.
You can't move forward because it all asks for numeric information.
Okay.
So that's a slight caveat, but
Other than that,
other than that,
So-
it's efficient.
you prefer this system, or you?
I personally prefer the paper version.
Paper version. I think like any change, it will take some time. For the practitioners to absorb this change and then get used to it. Yeah, I think this is the way forward. Home Office wants everyone to submit online applications, and we can't do much about it. So if this is where it is, this is where it is.
It's going to take time to get used to it, but
Of course.
Yeah.
Thank you very much, Anand, for this update on
That's
this
okay.
system.
Moving away from the changes now, the more important issue, and I think we've received a lot of queries in relation to this as well, the issue of 39E in relation to long residence applications. How does 39E work? What is 39E?
Well, it's a very technical and sort of difficult issue as well. There is no specific case law on this matter. There are case laws that address certain issues when it comes to long residence. But when it comes to making an application using an exception under section 39E, which is basically an exception to the rule in my opinion. So the rule is you have to have 10 years long residence in the UK before you apply for indefinite leave to remain. And long residence is defined under the immigration rules is you have leave to enter or remain, continuous leave to remain in the UK. And it also includes whilst you are on bail or temporary admission under section 11, as long as you get subsequent leave. But unfortunately, if you look at the guidance for long residence, is specifically mentioned if you are on temporary admission or you are on bail under section 11, as long as you get subsequent leave, that part will be considered as part of your long residence leave to remain in the UK. But there is no such caveat, or there is no such restriction when it comes to section 39E itself. All it says is as long as you have submitted an application within 14 days of your leave being expired or your appeal rights being exhausted, you can make an application within 14 days, and any period of 14 days will be disregarded of you being illegal in the UK, which is obviously which does not mean that your 3C leave continues, because section 3C is very clear. Your 3C leave does not continue, but 39E, in my opinion, stands out alone in giving you an exception to the rule, which is that if you put in an application within 14 days, then this 14 days should be disregarded. And if you eventually get the leave on that, and then obviously your long residence continues. Problem comes in if you have put in this application using section 39E when you haven't finished your long residence, so you haven't finished your 5 years, for example, if you are on tier 2 or other conditions, and specifically for 10 years long residence, you haven't finished your 10 years yet. Let's say you have, in fact we have had case, my colleague Sharia, he had a case recently where applicant was 4 days short of 10 years, made an application 4 days less than 14 days, so altogether 18 days I think, and made an application within 14 days, and it was refused on the basis that you were 4 days short of your 10 years, even though application was submitted within 14 days using 39E. So this is something we have cases pending in the tribunals, upper tribunal and other venues, and we're hoping that now this issue is resolved. We are planning to obviously approach the tribunal that they have to come up with a defined strategy as to how 39E works. Does it work only if you're granted subsequent leave, or does it work regardless if you put in an application within 14 days? And if that application is pending and you finish your 10 years, for example, let's say you put in an application 3 months before you finish your 10 years, you put in an application within 14 days and you finish your 10 years whilst decision is not taken on the application, then what Home Office guidance says is that for 39E cases, a senior, the caseworker has to take guidance from senior case working officer, and Home Office should exercise their discretion in these cases. But then you have other cases where Home Office has taken a decision before you finish your 10 years, and then third scenario will be if Home Office has taken a decision with an in-country right of appeal, you finish your 10 years by the time you go on to your appeal hearing, and then you finish your 10 years. So all these issues are there. There are no definitive answers. Because of the discretion issue under 39E in Home Office's guidance, we get a lot of arbitrary decisions when it comes to applications, but there is no specific case law in this area, and we're hoping that soon one will come in.
Definitely. Okay, and there's also been a recent case about how Home Office, if they extend 3C, agree to extend it by mistake, is that acceptable? What does that recent case law say?
Well, basically what it says is something which is supposed to be an accepted principle anyway, because Home Office is an administrative body. They can't, so to say, for a lack of a better word, create regulations. They have to follow what Parliament has given them. They obviously can have their own guidance and explain how they understand those regulations. So if, for example, Home Office tells an applicant that your 3C leave continues under certain circumstances, but when it comes to the actual legislation or immigration rules, actually it does not. So for example, if someone puts in an application using 39E like we discussed within 14 days of their leave being expired, whilst their application is pending, they have no leave to remain technically, because they put this application in out of time. So if they had right to work before, their right to work will not continue under 3C because there is no 3C. So in certain cases, when employers do the employers checking, approach Home Office through employer checking service software, Home Office confirms right to work. Now, or any other scenario where Home Office has confirmed that leave continues for that person, when in reality it does not. In those cases, now we have a clear case law that in those cases, if Home Office has agreed to your leave being extended or 3C leave being extended by mistake, or they thought that 3C leave is extended when in under the legislation or immigration rules it does not, then obviously legislation will take precedent, regardless of what Home Office says. So they cannot by mistake or accidentally extend your 3C leave. Let's put it this way. So unfortunately, even if Home Office says you have 3C leave, if the law says you don't, then obviously law will be followed rather than the administrative body. In this case, UKVI.
Okay. And are there any recent inquiries that you received a lot that is so common that you've been asked the same query again and again? Is there anything that you would possibly feel the need of addressing?
Yes, I think one of the inquiries we have received recently and quite a lot is for under EA regulations, leave to remain or right to appeal for extended family members. We have discussed it in our previous programs as well quite a few times, but this is something we get regularly. Is there a right of appeal or not? Answer is, as per 2016 regulations, there isn't, but there is a case law, as I said, and Home Office has not defined their position yet. There is a case law now in place where courts are of the opinion that there should be one, because it's a fact-finding process. The only way you can find facts or give determinations is by going through this fact-finding process via the tribunal. If you have a statutory right of appeal, usually you can challenge it, but this is not a fact-finding process. So we have not seen Home Office coming up with a policy as yet, but we have a lot of cases pending on the same point, and I think these cases will be determined very soon, and higher appellate courts will decide whether there should be a right of appeal on these type of matters or not. So if you are one of those who have been refused extended family member application without a right of appeal, you can contact your representatives, your lawyers, you can contact our offices, we'll be happy to help, because if you are still in time, you can challenge that decision via judicial review and ask the court to have this stayed until position for the Home Office is defined in this case, or we have further case law confirming that there is a right of appeal. Okay. Other than that, I think a lot of questions we received was regarding asylum matters, in what cases we can apply asylum, etc. There is an appendix available on the Home Office website. So if you go to .gov website, there is an appendix available for asylum cases. You can look at the criteria. Basically, we have had cases approved even on the basis where females have faced domestic violence in their home country. They have come and they don't want to go back, even though relocation is an issue, or they have children in the UK who are, let's say, in need of special needs, and countries like, for example, Pakistan, Bangladesh, even India, in many cases they cannot, obviously the level of facilities they can't provide, but at the same time, because of the discrimination disabled people face in those countries, we have been successful in getting asylum cases approved for our clients who have children who are in special needs, and also clients who are facing domestic violence, or single mothers who unfortunately, or who cannot prove that they were married to their partners, or they were actually not married to their partners, they had a child out of wedlock, and now they can't go back to their home countries because of the laws they have in those countries, or or for example they fear persecution because of these issues. So we have been successful so far in this type of matters. So if you are interested, or if you are one of those who was suffering from one of these issues, then please contact us. There are a lot of questions as well online. So
yeah, there is a question in relation to fee waiver. It says, is there a part fee waiver, or is it yes, which means the application is accepted, or a no, meaning you will have to pay application fees?
I don't know exactly what it means.
I don't quite understand the question.
But I can explain how fee waiver works now under this new system.
Yeah.
My understanding is that now you have to make a fee waiver application separately. What the new system states is, when you make a fee waiver application, for example, you are someone who has a valid leave to remain, but you cannot afford to pay a fee for your further application. If you previously, problem was, if you make a fee waiver application along with your actual application itself for leave to remain, if Home Office refuses your fee waiver application, they would send everything back and your application is invalidated for the lack of fee, and then you make new application with the fee or challenge that decision, but in any case you will be out of time. Now this new system, good thing is, if you make a fee waiver application first and you are someone who has leave to remain, your fee waiver application will extend your 3C leave until the decision is taken on that fee waiver application. Once decision is taken and you are successful, you will be given a reference number which you can quote when you make an application. So you have to make an application for fee waiver first before you make the actual application for leave to remain in the UK. If your fee waiver application is refused, then your application date for the fee waiver will be, refusal date will be the date when your leave expires. So you put in a new application within 14 days. Obviously 39E will be applicable and you can make new application. So this is a good thing in that sense, but you have to make a fee waiver application first. I'm not going into a criteria of fee waiver. We have written on this, it's on our website, so you can go and check it out. But if you have to make a fee waiver application first before you make your application now under this new online system.
Okay. There is another question. I'm not going to go into the detail because he's put his entire case down, but in essence his question is, he's had a positive appeal and he's waiting for Home Office to implement that decision. He said, what can he do for them to implement? Is there a way? Is there a procedure? What can I do now?
Well, if I don't know at what stage it is at. If it's recently been approved, then obviously both parties have had 14 days to appeal against that decision. If Home Office decided not to appeal against that decision, then they will implement it as soon as they can. Generally they take about 3 to 6 months. You can write to the Home Office. You can even send them a notice asking them to implement it if there are any exceptional circumstances. If you are facing detriment somehow, for example, and you really need your visa quickly, then in those cases you can write to them. You can ask them. You can even send them a notice. Generally, they take about 3 to 6 months to implement it. It can take longer if they have to make further inquiries, etc. So it depends on case to case basis. I just want to mention one thing. When you send us your questions, you don't have to mention your personal details or you don't have to mention the specific facts related to your case. You can generalize it and ask us a question. So don't mention your name or your reference numbers, etc. Because when you put it on our Facebook online, everyone else can see it as well. So please make sure that you don't put specific details in. You can just generalize it.
Yeah, definitely. I mean, I guess for online questions, that is it. Unless if there is anything else.
I think that should be it for today. We have covered all the topics we wanted to cover. We have answered online questions as well. We will be away because, as you know, it's holiday season coming in. So a lot of my colleagues, myself, I'm away as well. So as soon as I think we will resume in first week of January with our usual live program. So till then, take care of yourself.
Yes.
And if you have any questions, keep posting. We are open other than public holidays, of course. If you have any queries, send us your queries. We also want to have a program specifically on how you can contact us through different means we have through social media. So we will have a specific program on that where my colleague Riaz will sit down and explain how you can contact us via different modes of contacts we have. For example, we have live chat option. You can contact us via a lot of social media means we use. So it doesn't have to be a phone call or an email, etc. So we will have a specific program when we come back with my colleague, and he will go through it with you, so that it will be more convenient for you to contact us. It doesn't matter where you are in the world, right? So thank you very much for listening.
Yeah, and I guess we'll see you next year then.
Thank you.
All
Have
right.
a good day.
Bye.